Recovering the Moral Foundation of America. Today on The Simple Truth, we consecrate everything to the Sacred Heart of Jesus through the Immaculate Heart of Mary and the pure, strong, chaste heart of St. Joseph. I'm your host, Jim Havens, and we are blessed to have an American national treasure with us today. Our guest is Dr. Hadley Arkes, political scientist, legal theorist, constitutional scholar, author, and professor emeritus at Amherst College. He's also the founding director of the James Wilson Institute on Natural Rights and the American Founding. You can find them over at jameswilsoninstitute.org. Dr. Hadley Arkes, welcome back to The Simple Truth. How are you today?
Fine, Jim. It's so good to see you, but it's tough. The late Tommy Magliacci said, I have a face made for radio. I'm not sure it's good to see myself. It's so good. Your introduction reminded me of that great cartoon in New Yorker of a 19th century garb, a vast statue, and on the ground people were like ants, and on the entablature it said, "Still patriot, author, but still a disappointment to his mother." Okay.
Well, I was
wondering when you gave that introduction, I was wondering who walked into the room that suddenly fit that description. But you're sweet. I'm glad to be here with you.
Yes, we're very grateful to have you here. And yeah, nobody can unpack this topic like you can, in my opinion. And so, yeah, we're going to start you off here with a big question. If we're going to recover the moral foundation of America, we have to first know something about what that is. The 250th anniversary of the official adoption of the Declaration of Independence is next year, which we take to be our nation's birthday on July 4th. Then the U.S. Constitution followed 11 years later, written and signed in 1787, ratified in 1788. What did our founders get right in terms of the moral foundation of America?
Well, actually, we had this odd spectacle of Senator Kane of Virginia the other day. It's shocked to see people take seriously the notion that our rights came from a creator. And he talked about natural rights that would vary from place to place. No, Lincoln said the great contribution of Jefferson and the Declaration of Independence was that they articulated these abstract truths applicable to all men in all times, regardless of the culture. What they're articulating there, in the Declaration of Independence, was the rights that flow to human beings by nature. And that's the understanding when no man is by nature the ruler of other men, in the way that God is by nature the ruler of men, and men are by nature the rulers of dogs and horses. And Jefferson said, anyone who denies that has to assume that the mass of mankind were born with saddles on their backs, and the privileged few were born with spurs on, ready to ride them. We begin with the awareness of a distinct nature that marks human beings within the order of creation, somewhere between the distinctly human set off against the subhuman and the superhuman. That becomes the source of those rights that flow to us by nature. So James Wilson, one of our premier minds of the American Founding, after whom we've named our own institute, James Wilson said, we didn't bring forth this new government for the sake of inventing new rights, but for the sake of securing those rights that flow to us by nature. That is, have that understanding of nature, understand no matter where you go, east or west, no man is by nature of the rule of other men, the way that men must be by nature the ruler of dogs and horses. Now, it's so odd that people have a hard time understanding this emanated from a creator. I mean, the founding generation didn't think that the universe and this whirlwind was an accident. And John, we can talk about this in your show. Leo the 13th, in that encyclical on human liberty in 1886 said, animals cannot have property rights because animals cannot impart a moral purpose to inanimate matter. The only kinds of creatures who can do that are creatures of reason. There's only one kind of creature who can make a promise, make a commitment, bear an obligation, and respect that commitment, even when it runs counter to his interests. As Aristotle told us, the polity, the political order, emerges from that kind of creature alone. And of course, where do we get these creatures of reason who have access to the laws of reason? Well, as the Declaration of Independence say, from the creator of it all, from nature's God, the one who brought forth this distinct human nature as he brought forth the laws of physics. So, we're brought back again to those just anchoring truths. It's amazing to me how somebody like Senator Kane can get on it long into his years as a lawyer and a political man and having all this coming as kind of news to him that he's never thought through this matter.
Let's stick with that example of Senator Kane, because there are probably a lot of people that would hear Senator Kane make those remarks and think, oh, yeah, I agree with him. This is some sort of religious tyranny talking about the creator or something. And so the fact that we have lost this. So is this this is in terms of where we have to look at some sort of sense of religion. I know everybody just wants to say, well, there's no religious aspect. Let's forget about the religious aspect. Let's just try to find common ground on reason alone, all of this. But we have to have some sort of religious aspect, at least at the most basic level, don't we? To be able to say there is a creator and we are created beings, and we have to have some sort of common ground there at the very least, don't we?
Well, I think so. I think it's Ronald Knox, the great theologian and priest, once remarked that, hey, we name scientific laws after the accomplished men and women who discovered them. So we talk about Boyle's law on gases. But as he said, it took a considerable mind to have discovered that law. It must have taken a considerable mind to have put it there in the first place. The people of that founding generation had a sort of a good, even without talking yet about Christ or Moses in Jewish tradition, they had a sense that no whipping of the wind would give us the Cathedral of St. Mark's. Something like that, a cathedral of that kind, or the Liberty Hall in Philadelphia, that bespeaks a design, a purpose, and a design. And the world that contains the principles of architecture could not itself have been a random happening. I mean, in that founding generation, people could have this access to have a sense of natural theology. It told them that there must be a beginning to things. There must be a beginning to a material order that is not merely material. And of course, the founders understood that for every liberty we could mention, Jim, every liberty to speak, liberty to walk about, there's a converse form of license. Any liberty could be directed to a rightful or wrongful end. And so, of course, James Wilson, and among the founders understood that if this whole order, this universe, had to have a creator, that creator could not have been morally indifferent. It must have come along with a sense of the rightful ordering of these things in the first place. And so when we go back to the Declaration of Independence, it's just hard to argue, untenable to argue, that the same God, the same creator, who gave us the universe and gave us the laws of reason and gave us the moral law, could somehow endorse, accept as religion, Satanism, the radical denial, the radical affirmation of evil. John Adams said this regime, this republic could be run only by a religious people. It matters profoundly if you have a sense that there is a law outside yourself that you must respect. And the presence of God gave us a kind of lead into the awareness of a moral order outside ourselves that could always reinforce. In the library of my late father-in-law, I found a biblical commentary by Meyer Waxman on, I think it was in Kings 2, where Elijah was lodged at Mount Horeb, and he was told by God to go to Damascus and I think install Hazael as ruler. And the commentator said that this passage from about 9th century BCE was an indication of how early the Jews were committed to monotheism. Well, I thought Jews were always monotheists. Well, no, my friend David Novak said, well, at one point, the Jews were henotheists. They recognized a God of Israel. But I used to put the question to my students, what is there in this story that would indicate monotheism. And the point was that the God who could tell Elijah to move across that boundary and install a monarch somewhere else was evidently not one of those local gods known to antiquity. It was a God of a universal jurisdiction. Right?
Yes.
And so we'd say, the music is coming in on me, so I must be mistiming myself. But the point is, once you understand that the Ten Commandments were not merely municipal regulations about the immediate vicinity of Mount Sinai. They were meant to be universal in their reach.
Yes. Yeah. Some things are true. Absolutely. And again, this is entirely reasonable. And the fact that there is a creator is entirely reasonable. Everything lines up with right reason. And so one other aspect, you bring up the biblical accounts, you can go to Genesis, monotheism, and you think about the creator. He's creating the sun. He's creating the moon. He's creating the stars. He's the creator of all things. Those things are not gods. He is God, and those things are part of creation. We'll be right back. Stay tuned.
Tired of your phone bill supporting who knows what? iCatholic Mobile is a 5G provider that supports what matters to you. With iCatholic Mobile, every call, text, and even that group chat you can't escape helps support the Station of the Cross. It's a network that connects you to what's good for both your soul and your wallet. More information is available at iCatholicMobile.com. iCatholic Mobile underwrites with the Station of the Cross.
Welcome back to The Simple Truth. Jim Havens here with our guest today, Dr. Hadley Arkes. He is the founding director of the James Wilson Institute on Natural Rights and the American Founding, jameswilsoninstitute.org. By the way, he's also the architect of the Born Alive Infants Protection Act. So much good that has been done by Hadley Arkes. We're very grateful to have him here. We're going to dive back in to the conversation right after this. But first, if you are buying or selling a home, there's an easy way to help the Station of the Cross at the same time. Real Estate for Life has 1,400 experienced, morally grounded agents in the U.S. and Canada. Visit realestateforlife.org to find a Christ-centered, experienced realtor near you. And don't forget to mention the Station of the Cross. Also, Hadley's going to be speaking on just this upcoming Thursday, October 9th, a pro-life symposium, Defending Life at Conception and in the Constitution. For more information on this, is going to be at Catholic University of America. For more information, go to wakeup.mom to learn more. That's wakeup.mom to learn more. All right, Hadley, I want to turn real quick to something that you wrote in your great book, Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. Did a whole hour with you on this book the last time we had you on. Folks can go back and find that. I wish I could spend hours and hours with you talking about this, but there's one thing I wanted to bring up here today. You write this. You write, "I must count myself for the record as an original originalist. For many years, I had the privilege of teaching on the American founding with the sublime task of reading closely the writings of those remarkable men who shaped this American regime and the Constitution. Men such as John Marshall and Alexander Hamilton had a knack of tracing their judgments back to those anchoring truths that were there before the Constitution, truths that would be there even if there were no Constitution." So these anchoring truths, you mentioned in the last segment, this is what our founders wanted to protect and express in our founding documents, in the Constitution. Now, all these years later, almost, well over 200 years later, almost 250 years later for the Declaration next year, we look at this and the Constitution now grown, 27 amendments. And yet it seems that as a people, we have lost a lot of these anchoring truths that the Constitution was actually put in place to protect, that actually precede the Constitution. How do you make sense of that? How do you look at the problem as we have it today?
Well, actually, ordinary people have not lost those anchoring truths. Those, the way I go, I follow my hero James Wilson, who relied on that great 18th century philosopher Thomas Reid, who was read closely by Jefferson and Adams, who would go back to those precepts of common sense that the ordinary man had to know before he started trafficking in theories. And so the ordinary man would readily grasp that first principle of all moral and legal reasoning that, as Kant put it, you don't cast judgments or blame or praise on people for acts they were powerless to do. So we say that we don't hold people blameworthy or responsible for acts they were powerless to effect. If the ordinary man were told where Jones was undergoing surgery at the time was committed, he'd wonder why he's being prosecuted. The ordinary man grasped that. And the ordinary man grasps also the main principle of the founder. If you ask the ordinary man, Jim, why in this age of animal rights we're not signing labor contracts with our dogs or horses, or seeking the informed consent of our household pets before we authorize surgery on that, the ordinary man would be confused. What are you talking about? Why would I think of signing a contract with a creature like a cow or horse who can't reason about matters, make a promise, bear a commitment? But the older man who senses that grasps what I described earlier as the main organizing principle, that you cannot rule human beings the way human beings are compelled to rule dogs or horses. The natural differences between in nature, those differences in nature, would mark the enduring rights of human beings. Ordinary people understand these things. It just takes a dose of theory for people to tell themselves they don't know what's in the human womb. We used to, the founders were not so in the dark about these things. James Wilson put the question, if we have the human rights, natural rights, when do they begin? And his answer was, we begin as soon as we begin to be, which is why the common law casts its protection over human beings from the first stirrings in the womb. Now, it takes really an overdose of theories to put lawyers and judges in the position, say, of Justice Kavanaugh in the Dobbs case several years ago, striking down Roe versus Wade, where Kavanaugh said, well, isn't it interesting that some people actually believe that nascent life in the womb is human? Believe it as though we didn't have 90 years of embryology to give us very precise material evidence on this point? What is it? Something has been lost, but it's not lost among ordinary people. Ordinary people see women pregnant and they have no doubt they're dealing with a human being. Judges have to be agnostic on that question. As though somehow it's become indecorous for conservative judges to pronounce a judgment on the central issue before them in a case on abortion. So the court could strike down Roe versus Wade a couple of years ago without pronouncing on the human standing of the child in the womb. Somehow the conservative judges have talked themselves into the notion that is somehow not something that they should be recognizing. So it's there has been a lot of backsliding, and the American people have been gone untaught about, I guess, those precepts I mentioned in the opening lines of this conversation, Jim. The odd thing is that it comes as news to so many Americans. They have it within them. And when we go back to these underlying principles of natural law, or these axioms of it, like most people understand, you don't hold people responsible for something that was done before they were born, or things they could not affect. Most people understand that. It takes a good deal of when you alert people to this, they have the sense that they've known them all their lives. Spinoza said, if Moses dropped those 10 commandments, they'd still be there because they'd be written in the heart. Those commandments would still be there. They wouldn't disappear, even if the stone disappeared.
Yes. Yeah. Many important distinctions there. Hadley Arkes is with us, jameswilsoninstitute.org. That distinction between the ordinary person versus the academy, the courts, other American legal institutions. I do want to just push back a little bit on this, because when you look at various immoral things that have become very popular, the Supreme Court. The Supreme Court had gotten things wrong, certainly with respect to abortion, now with respect to so-called same-sex marriage. But look at the population, right? You would say, there's a good portion of the population, around half or so, I guess they're not so ordinary in terms of ordinary people anymore because they've lost this moral sense, it seems, on these anchoring truths as well. Doesn't that seem clear? How do you explain that?
Well, they could be obliterated, can't they? When you find an institution like the Supreme Court arguing for 50 years about the rightness of abortion, that we can't recognize that nascent life in the womb as a human being. Well, what do you expect when you've had 50 years of that kind of tutoring of the American people coming from an institution they regard as an institution of importance, of high standing, of authority? Of course, the laws teach, when the laws established in 1964, that it would be wrong to discriminate on the basis of race in private businesses open to business with the public. Well, that law sort of lifted that choice of discrimination. It lifted that choice from the realm of taste into something now forbidden as a public obligation. Well, the law does that. It teaches a new lesson to people. Left to themselves, ordinary human beings do have access to these principles of moral judgment. They can reason about these things. Of course, people would be reasoning in perverse ways. Of course, people would be reasoning with a sense of their own self-centeredness and it's seeking their own selfish profit, regardless of the cost. But it matters profoundly if the law has been teaching profoundly the wrong lessons for these years. The public itself, even liberal California, remember, was voting in a referendum to preserve marriage as we know it, the union of one man and one woman with a commitment bounded in law. Even the people of California were willing to vote for that. It took the courts. It took a certain class of people armed with the authority of the law as judges to overturn that judgment and use the power of law then to teach emphatically and persistently a new lesson, to punish people if they hold to the older view. Well, you can't go through periods of this kind without people sort of either grasping the lesson, grasping that they better just be quiet or shut up and preserve those principles for themselves in their private settings without saying much about them. And after a while, one loses one's conviction about these things. No surprise, there isn't. No surprise that the wrong lessons can be taught with the force of law.
Yes, yeah. Okay, and so then
that doesn't. Mm-hmm. It doesn't extinguish the possibility that once we start teaching again, ordinary people can get it again.
Yes. So that leads to the question that we can find on the website, jameswilsoninstitute.org. The question is, how do we restore natural law in the academy, courts, and other American legal institutions? What do you propose?
Well, we'll teach again. Teach Lincoln and Hamilton and James Marshall how they're able to draw their judgments back to England. Remember Hamilton's line to Federalist 31: in disquisitions of all kind, there's certain first principles or anchoring truths from which all subsequent reasonings must depend. Now we go through this, that there'd be like the axioms of kinds cannot enclose a space. Two things equal to a third or equal to one another. And of like nature, those maxims of ethics and politics. There cannot be an effect without a cause. The means must be proportionate to the ends. People can understand these things. When you go back to the way our jurists, people like John Marshall, Alexander Hamilton, took the trouble to bring people back to those anchoring grounds of their own judgments to show how they got there, what the grounds were, so that John Quincy Adams could say that your right to petition the government, it's simply implicit in the very idea of a free society. It would be there even if it hadn't been mentioned in the First Amendment. It would be there even if there were no First Amendment. It would be there even if there were no Constitution.
Yeah, Dr. Hadley Arkes is with us, and this is a fascinating, very helpful conversation with Dr. Arkes today. We're going to be back with more in just a moment, but yeah, I mean, when it comes to these these first principles, natural law, anchoring truths. As we talk about these things, it's important to be formed in them ourselves and then to be able to engage people on the substance of various issues that are out there, controversial issues of our time, from the point of view of these first principles, and to help people to see them and then to reason from there. We want to be able to restore this in the academy, the courts, other American legal institutions, but also sort of hand-to-hand combat for our fellow man, to lead them ourselves. That's part of our job. We'll be right back. Stay tuned. Welcome back to The Simple Truth. Jim Havens here with our guest today, Dr. Hadley Arkes. You can find more about him at jameswilsoninstitute.org. But he is the author of several books, including Mere Natural Law, Originalism, and the Anchoring Truths of the Constitution, which distills a lifetime of reflection on natural law, constitutional jurisprudence, and the moral foundations of legal reasoning. Highly recommend it wherever you find books. Check out Mere Natural Law by Professor Dr. Hadley Arkes. And we're going to get back to the conversation in just a moment. But first, don't forget about iCatholic Mobile for your mobile phone needs. When you subscribe to iCatholic Mobile, you do help fund the Station of the Cross. Check out iCatholic Mobile, iCatholicMobile.com. Dr. Arkes is also going to be part of this pro-life symposium on Thursday at Catholic University of America. If you're anywhere near D.C., definitely drop in on that. You can learn more by going over to wakeup.mom. That's wakeup.mom to learn more. I just want to make sure, Hadley, that we're not getting that nobody gets lost in the various terms here. When we use the term natural law, when we use the term first principles, the term anchoring truths, all of those terms, we're talking about the same thing, correct? And then, if we want to form ourselves in these first principles and natural law and these anchoring truths, which we would be wise to do so. Is there an easy way? Is there a list somewhere where we can view these principles and kind of digest them? What do you recommend?
Well, some of us have written on this subject. I wrote a book called First Things years ago, which late Father Newhouse took as the name of a new journal called First Things. My friend Robbie George has written a number of things on the clash of orthodoxies and making men moral, and John Finnis has a book on natural law and natural rights. And we have we can have other people who've written about these things. And of course, there's mere natural law that you've just pointed out. But it's worth picking up what you just said. But Jim, it's important for people to understand that whatever it is we're talking about, natural law has to be something anchored in an objective truth. It's an objective truth that John Paul II would say about the human person. What is there about the human person? Again, going back to my remarks about Leo XIII, rational creatures who have been given to understand reasons over matters of right and wrong. They can't be ruled in the way you rule dogs and horses. The natural law arises from things that are most distinctively natural to human beings, which is, as Aristotle would say, not really that we can emit sounds to indicate pleasure or pain, but that we give reasons over matters of right and wrong. And one of the features of this constitutional order of ours is that we create different fora, which people trying to make policy are compelled to give reasons. Either give reasons in the House of Rep, give reasons to another house, give reasons to an executive who has to sign the bill, give reasons if the law is drawn into courts for challenge there. It's a regime predicated on the notion that creatures who can give and understand reasons deserve to be ruled with a rendering of reasons. And again, people like James Wilson and Alexander Hamilton understood that everything we know has to start with certain anchoring truths, like the law of contradiction. The first proposition in the laws of reason. Two contradictory propositions both cannot be true. On that once again, I can never tire of saying that first principle of all moral and legal reasoning. We don't hold people blameworthy for acts they were powerless to effect. Now, people can be surprised by how many things can be drawn from our jurisprudence, from things of that kind. So it's a matter of reading again. But, if you'll permit me, it may be useful to go back to into Obama and Lincoln for a moment. We have a time because Mr. Obama thought it's interesting, but he did not think, as Lincoln and the founders thought, that the American regime was really based on a self-evident or necessary moral truth. He thought all men are created equal was just an idea. He thought all moral truths are only relative to the historical epoch in which they were held. He didn't fully accept it. He didn't understand it. He didn't simply understand that we're talking about something fixed in nature, that no matter where you find human beings and other animals, human beings may not be governed the way we've governed horses and cows. And I remember Lincoln bringing this point through, saying that black woman may not be my intellectual equal, or maybe my social equal, but in her right to eat the bread she has earned from her own hands, she is indeed my equal and the equal of any other man. In other words, he's talking about the deeper understanding of our natural rights. We are the owners of ourselves. We are the owners of our own labor. That woman, too, had a right to be governed with her consent. And I remember a student of mine coming back to my office one day saying that he's never was enamored of natural rights the way I've been. And as the conversation continued, I pointed to this character in the gutter who's broken his own life, and I asked him, why do we still treat him, even in his broken state, as a bearer of dignity and rights? And my student began to give me kind of postmodern song and dances about how we view him, how we see him. I said, well, you're talking about us and the lens that we use. You start talking about him, that man in the gutter. What comes into play there, Jim, it comes into play more decisively than anything we get from the Greeks, is Lincoln's point. Nothing made in the graven image, nothing made in the image of God was sent into this world to be imbruted, to be treated as a nothing. You don't get that from a syllogism. You don't get that strictly from anything that comes out from classical philosophy. There's a Christian-Jewish component there. This is why we understand that biped who conjugates verb, that human person, as bearing a dignity and having a claim to our respect. That we say, if we're going to restrict his freedom, if we're going to take his life, we must give the most compelling reasons to justify anything we do in regard to him. That's the core of the problem. And it is amazing how people like Barack Obama have talked themselves out of it. They thought, oh, yes, it was a matter of, they meant all white men were equal to all white men in Europe. And Lincoln exploded that. He said, if you listen to Douglas, if you listen to that argument, then it appears that the Americans in 1776 were equal only to the Scot-Irish. Then all the Germans and the Catholics who came later, they're gone to pot, along with the other. Lincoln saw that argument and dispelled it right away. Of course, the Declaration of Independence applied to all men, black as well as white. There are people who wanted to deny it, didn't want to recognize it, but it's very hard for them to deny that the very logic of it had to encompass all human beings, all human persons.
Mm-hmm. Yes. Yeah. Dr. Hadley Arkes is with us. What's interesting too is that, so this is kind of where we left off even in our conversation last time, is about how originalism doesn't really get to the heart of it. And so, right. And that's interesting because these are folks that are otherwise, I would say, ordinary people, but they're entering into a sort of judicial or sort of legal view that thinks, well, the only way we can interpret the Constitution is just based on the text alone and the history of the text. But the fact is that if that's true, you take the history of the text all the way back to the beginning of the text, it is protecting these natural laws, these anchoring truths. And so how can you look at the history of any portion of any of the Constitution and not see that it has these anchoring truths that it's flowing from? What is your thought on that? How has originalism sort of missed the main point here?
Well, because originalism try. It's somebody, even some friends of mine, late friends of mine, who were really did not were held to the positive law, the law that is posited or enacted, and they became very diffident as soon as they begin to talk about moral truths, and they're reluctant to recognize any moral truth apart. So one thing I want to say is we have to be governed by the moral truths that were at least contained in the text of the Constitution. What was behind it is a notion that a deep doubt that there were indeed these moral truths that were outside the text, or in the case of Scalia, a kind of a deep doubt that we can depend on people to know them, to get, as Scalia said, we can't get a consensus on that point. But of course, what moral truths depend simply on consensus? When he would say that, we'd say, well, did you get a consensus on that point? That we know moral truths only through a consensus. But the point is that people are compelled to keep going beyond the text. You've heard that proposition, presumed innocent until proven guilty? Well, that's not in the text of the Constitution. Why are people convinced that that is there as though it were, in fact, written in the text? The historian Jonathan Gienap has pointed out to the work of the great 19th century scholar Thomas Cooley, a great commentator, who point out that the due process clause in the Constitution was a great device. They'll allow us to just draw out the logic of all those natural law principles that the founders had to understand, but didn't think that they had to put down in the text of the Constitution. In fact, we know Oliver Ellsworth and James Wilson didn't even think we should mention ex post facto laws, holding people responsible for things that were not illegal at the time they were done. They thought it was so obvious, there's no need to say it. But little by little, courts have been drawing those things out, like the rights of parents to arrange for the education and to govern the medical treatment of their own children. That's not in the Constitution. But we can argue that is very plausible as a natural right. Or as my friend Dick Holman at the University of Chicago said, a summons. That don't you think that anyone targeted for criminal punishment should be alert to the fact that he is being targeted? He should receive a summons. Well, the founders never thought of putting in a summons there in the text of the Constitution, nor did they think they really had to say that parents had, of course, natural kind of right to arrange for the upbringing, the education, and the medical treatment of their own children. So the problem with originalism is they bring us back to an originalism detached from the underlying judgments of the founders, the American founders, who understood the very moral ground of the political order they were putting into place now.
Right. Yeah. It seems to, again, it sort of refutes itself in a way. It's a major problem. And the fact is that you mentioned in the end of our last conversation that there's a sort of fear that, well, if we didn't do it this way, if we just brought up the category of moral reasoning and we actually dealt with the substance of things along those lines, well, we're afraid that, the more liberal justices, if we just let them sort of do some moral reasoning, that's going to go very poorly. What's the argument, though, that we need not fear that? Isn't it because, well, then we just engage upon that arena of conversation of moral reasoning and the truth wins in that case, doesn't it?
Well, it may not always win. We can't guarantee winning. We can guarantee at least being committed to making the most coherent argument we can. The problem with our friends say, you see, look at the mischief that people cause when they engage in moral reasoning and give us these extraordinary things. We'll say, so you're going to solve the problem by simply disarming ourselves from moral reasoning. If you think that these other people have produced reasoning that's bizarre and specious, then the corrective to it is not to abandon moral reasoning, but to engage that same reasoning to show where they're wrong. So we should just have the confidence of
Yes, we're going to get back in one final segment. We've got Dr. Hadley Arkes, one final segment here today. Very much looking forward to that. We're going to open up the floor and allow him to lead the way if there's anything more he wishes to say. But I certainly have many more questions, but we'll see where the conversation goes. But what a blessing. There are some great people. He mentioned a couple that do teach on natural law, Robert George, John Finnis. Something special about Dr. Hadley Arkes. We're going to be right back. Stay tuned. Welcome back to The Simple Truth. Jim Havens here with our guest today, Professor Dr. Hadley Arkes. He is founding director of the James Wilson Institute on Natural Rights and the American Founding, jameswilsoninstitute.org. Mission of the James Wilson Institute on Natural Rights and the American Founding: to restore the American founders' understanding of the moral grounds of our rights by bringing back a common sense foundation to the study of law, to inspire a new generation to discover anew our nation's absolute truths. Seems to me that this work is exemplary in terms of the way that it is pushing back against the dictatorship of relativism in our time that Pope Benedict XVI used to speak about. And just very, very, very grateful for it. And I want to give you the opportunity to speak to whatever you want to speak to, Hadley. I have a follow-up on what we were talking about before. But first, I just want to make sure that anything you want to get in today or you feel a strong sense to speak to, you have an opportunity to do that.
You've given me plenty of. There are a few things I could do, but let's see what you have tucked away, Jim. But I pick up a point you made toward the end, that when people tell us we should not go beyond the text of we should stay with the Constitution, the text of the Constitution, and we should be fearful of going beyond the text of the Constitution, inventing things that are not there. And I think you were suggesting, that very principle is not itself contained in the Constitution. They're adding to it. How did you come up with that kind of thing? As my late friend Scalia once said, it's an axiom of the First Amendment that we may not make restrictions on speech based on the content of the speech. Now that's interesting, but that's nowhere in my text of the First Amendment. So where did he get it?
Yeah, I wonder.
He must have thought, as Hamilton said, it's something that sounds just sensible in itself.
Yeah, look, I mean, here's the thing. Here's the paradox of it, is that obviously Scalia is a very intelligent man. He was a great justice, and many others like him. Now we've got Justice Barrett in his mold to some degree, I suppose. I mean, these are and Gorsuch. Like, we've got these strong originalists, and yet there seems to be something missing, because there seems to be a problem with their originalism, which doesn't go to the substance of the thing, and it doesn't go far enough into those anchoring moral truths. And so I wonder, I guess what I'm wondering about is, it's, when you have people who are so incredibly bright and for some reason they're still not seeing that there's a problem here, what else is going on? I wonder if there's another fear that might be there that they may or may not be aware of, that maybe there's a fear that, well, if we didn't do it along these lines of this textual originalism in the way that we're going about this, then too much is we're actually going to change too much, getting back to those anchoring truths, because our society is so far in a different direction in the secularist way that it has tended to over the past many years. And so, if we just say, look, abortion is outlawed, which clearly that's the case when you look at first principles, there's no debate here. We cannot kill innocent human beings. That's what we're doing every day in this nation. And they not ruling on the substance of that. Also, same-sex, so-called same-sex marriage and many other things. Are they just afraid of the backlash of what happens if they actually don't do it in that originalist way? But as you say, the original originalists, going back to those first principles, if they did it that way, it may change some things, rightly so, and you can't fear, I guess, what may or may not happen next. Well, I don't know. What are your thoughts on it?
Well, I'll try to say something in their defense, but it brought back to Jefferson's line, where he said you could give the same moral question to a plowman and a professor, and the plowman is as apt to get it right because he won't be distracted by these artificial rules, call them theories. What is it that intervened between James Wilson, indicating that we have natural rights as soon as we begin to be, which is why that infant stirring in the mother's womb had them? What intervened between James Wilson and Brett Kavanaugh, except lawyers being given a dose of theories to try to explain to them why they can't recognize the human standing of the child as central to this question that's before them in abortion. They want to think that's beyond their pay grade. And what's at work with them, I think, is you find it with Scalia when the court struck down, installed same-sex marriage and put people who defended marriage as we knew it in the position of people who were bigots. And Scalia said, it's not my business to say anything about marriage. The laws can make marriage anything that the legislators wish to make it. I'm more interested in the fact that 320 million Americans are being ruled by 9 judges. That is, it just can't be that the matter of what constitutes real marriage is really outside the province of judges, and to ponder in mulling over that question in a serious way. What his concern there, what he's seen with the imposition of Roe versus Wade, or the overturning of the judgments of referenda people on marriage, is that a handful of elite judges, drawn from the best law schools, were constituting themselves a class to rule America. And what they were doing was leaning against it. They would avoid the main substantive questions for the sake of simply affirming the question, who has the right to rule, and putting things back into the public arena, perhaps on the assumption that Machiavelli held that the ordinary people as a class are probably more conservative than their rulers. Bill Buckley got to this the same way, didn't he, when he said he'd rather be ruled by the first 200 names in the Boston telephone directory by the faculty at Harvard College. They suspect that American people out there, if they're making laws on these subjects, would make more decent laws than judges are likely to make, armed with their theories. They had something going, but the problem is they talk themselves out of their understanding of those deep principles that would have to be there, that cannot be dependent on the positive law, the principles that were there before the positive law. And so they cut off they seem to deny, in fact, hold out warnings that it's too dangerous for us ever to try to make that move to those principles that were there before the fall. And yet, I wrote a book called Beyond the Constitution to point out that judges are typically making that move. Felix Frankfurter years ago, the Fifth Amendment, it says people may not be compelled in a criminal investigation to be witnesses against themselves. Well, where's the accent fall? Is it on themselves, or is it criminal fault? If we gave them immunity, could we now force them to testify against their friends in the Communist Party? That is, Frankfurter knew that he had to go beyond the Constitution in order to understand what those terms in the Constitution meant. And judges that in those early days did show us the value of taking their readers back to the anchoring those truths that were there. John Marshall said the Constitution gives us Congress the power only to punish piracies on the high seas. But if Congress can establish federal mails, it must be able to protect the bales from theft. Well, once again, you find judges in the past and that first generation of scholars who had a knack of tracing their judgments back to those principles that were there before the Constitution and would be there even if there were no Constitution.
Dr. Hadley Arkes, JamesWilsonInstitute.org. His newest book, Mere Natural Law, Originalism and the Anchoring Truths of the Constitution. You can't go wrong, I'm sure, with any of his books. But very blessed to have you with us today, Dr. Hadley Arkes. Thank you so much.
Oh, thanks for inviting me in, Jim.
Absolutely. Again, jameswilsoninstitute.org, jameswilsoninstitute.org. We all have a responsibility to be forming ourselves in these anchoring truths, reasoning accordingly, and dialoguing with others. God bless you all.